What exactly is excessive force? The amount of force that can be used by police officers when they are making an arrest is somewhat controversial. While we know that when an arrest is being made, the officers have a right to use some force, if they were to use excessive force, they may find themselves at the wrong end of a lawsuit. In some cases, the use of excessive force may be viewed as an intentional tort. What exactly is excessive force? Under federal law, there is no exact definition of what excessive force is. The court must decide whether a police officer, for example, would have used the same amount of force if they were in a similar situation. This will be considered during a lawsuit when the use of excessive force was considered to be a violation of an individual's Fourth Amendment constitutional rights. If, for example, a suspect was resisting arrest, the amount of force that is used by a police officer may be justified, as they will need to use force to subdue the suspect. The amount of force that will need to be used will depend on the situation. Would tackling the suspect be a sufficient amount of force? Did they pose a threat to police officers and civilians that were close by? Did the police officers need to use a firearm or taser against the suspect? The court and the jury will need to take a look at the reasonableness standard, which determines if the amount of force used is reasonable. When the court looks at a case of excessive force, they have to take every circumstance into consideration. Please note, the individual that was on the receiving end of the force does not have to be found guilty of the offense that they were arrested for. Different factors will be considered, including any verbal statements that the suspect gave, whether they refused to comply with an officer's verbal commands, whether the suspected was being arrested for a violent crime, non-violent crime, or a misdemeanor. The plaintiff, the person who was arrested, has to show that the force used was sufficiently serious to implicate their constitutional rights. If, for example, the plaintiff was pushed down onto the sidewalk and they were bleeding and bruised because of this, the actions of the officers may not be considered unlawful, even if the amount of force used was deemed a little excessive. The 8th and 14th Amendments. If the plaintiff is a convicted prisoner, the amount of force that is thought to be reasonable, when compared to excessive force, changes. Prisoners are protected by the 8th Amendment's Cruel and Unusual Punishment Clause. If the prisoner wants to prove that they were subjected to excessive force, they will need to show that the officer sadistically or maliciously used force in order to cause harm. Excessive force in this respect can be quite hard to prove when it is compared with the Fourth Amendment. Typically, the use of force in a prison that is used to restore order is not considered to be excessive. In order to be found guilty of using excessive force, the officer would need to have acted in an excessively cruel or extreme manner. If the plaintiff is in government custody but they are yet to be convicted, any excessive force that has been used will be considered a 14th Amendment violation. The definition of excessive force used in these circumstances can vary from jury to jury. In cases such as these, it is up to the plaintiff to prove that the police officer wanted to punish the inmate without any legal governmental purpose. Battery and excessive force. The excessive force that has been used by police officers is a form of battery. Depending on whether a state or federal law is being used, the amount of force used against the plaintiff may be considered to be battery or excessive force. If a plaintiff was trying to sue the police for brutality using a state law, the force that has been used will be known as battery. Battery is a civil wrong that has been committed by one person against another person. Known as a tort, the definition of battery will vary between states. In general, battery involves the act of intention. In other words, the police officer intended to cause offensive physical contact with the plaintiff without their consent. Using physical contact means that the police officer touched the plaintiff, and the contact was made with the plaintiff's body or their clothing. One of the defenses that are often used in battery cases is referred to as a privilege. A battery will be privileged if the contact was equal to a reasonable amount of force during the arrest. As the underlying considerations are the same as those found in an excessive force case, the plaintiff will either win or lose both battery and excessive force claims. The amount of force that can be used by police officers when they are making an arrest is not always clear. However, if you think excessive force has been used against you by a police officer or another individual, please speak to a lawyer as soon as you can.